Well, hi again. It's Rob Ryder, and it is Sunday, March 17th, 2024. If you've been following along, I've been showing a case in Texas that we filed uh, based on the fact that the real estate transaction that really everybody's involved in, right? Doesn't really matter, is a deceptive practice by the people involved. And the evidence of this was the fact that the homeowner has a signed contract with a broker, real estate broker, and in the contract it says that closing is defined when the legal title has been transferred to the buyer. And so then the question comes, well, what is legal title? Right? And they're going to want you to believe that's your warranty deed or whatever you call your deed, grant deed, whatever it is. But it isn't. Your legal title is a survey. And that'll be a survey that will be pictorially shown as a map, and that map will be stamped by God knows how many different individual entities, and it'll end up being filed in the county record. And one of those entries on there will say who the owner is, and it will have your name on it. And when you have that in the record, then you're the owner. But if you don't have that, you don't have legal title. You may have possession, which is equitable title, but you don't have legal title. Right? So possession is 9/10 of the law, but the other 10th is a legal title, and this is why they can get you to abandon the property so you no longer have possession. Then the legal title owner can take it back. Why they have to get you out of the house as an eviction or whatever they do to get you to leave the property, and then, under common law practices, then the legal the title holder can have the property back. Legal title holder. And so I've shown that these documents exist for the people who have the property prior to the current homeowner, but she doesn't have it. And that's what the deal was. So it's like, well, let's take because the only people in a real estate transaction that you have a contract with, that you signed it and they signed it, is with the broker and then with the buyer. In which case the broker was acting as your agent with the buyer, so he's involved in both of them. Now, if you didn't use a broker, you did it some other way, I don't have your answer. I don't know what to tell you. I'm just telling you, this is how it works in this case, which is how most people did. So if this is how you bought your house, fucking pay attention and, excuse my French, but, somebody else besides me needs to go file some paperwork and see what they can get done. I guess that's what I'm trying to get to. Right? Because if this is what works, then everybody has to do it. And the only way to do it is to go try it. And that's why you do it in small claims court, because it doesn't cost much. And it's much easier to do if it's somebody who just recently bought their property, because all the paperwork's still available. And with that information is all you really need to go file a claim in small claims court. Properly serve the defendant to get them to answer. So now that they've answered, game is on. But as it turns out, what I would say now, after having gone through this, at that point, the next thing I would do is request alternative dispute resolution and get the court to order it. Because it's been ordered, adjudged, and decreed. It's the judgment of a court that the situation should go to mediation. Right? And because it's court-ordered mediation, it's they have to participate in good faith, which has a definition. I mean, I did a whole video some years ago about the fact that the Supreme Court says that the courts have no jurisdiction in matters of faith. It's not up to them to decide faith. Right? They're just looking at a record. But the one who can decide the faith, well, back in the day, that would have been the church. Because the earl and the bishop sat together, and all cases would go to them, and the earl would wait for the bishop to decide if what had been done in good faith or not. And if it had not been done in good faith, then the earl would pass judgment and give the execution of whatever the civil judgment was, which in most cases was, back in those days was, cut off your hand or cut off your head. Just depending on what you did. So we've come a long way since then. Um, but when you go to court, you're going into an adversarial system. That's what common law is. And adversarial means you're at war with your neighbor, which is unchristian. So you're into the Judeo side of the Judeo-Christian system, where Jesus is the mediator for Christians. So we're supposed to go to mediation. We're not supposed to take people to court. Go to mediation. And the judge will agree with you. And now his hands are clean because he got it off of his docket properly to the place it should be. So now what is somebody who has a signed contract that says this is what you need to do, and they haven't done it, and they have to go to mediation and mediate in good faith, and what are they going to have to do? Yeah, that's right. They're going to have to give you the freaking title. Case solved, right? And what is the title? No, it's not a warranty deed. No, it's a survey. In 30 states, it's called a cadastral survey. In other states, they didn't use that system, so they call it something else, but it's still a survey. And at the end of the day, it's a survey that has a whole bunch of people agreeing that you're the owner. They've all stamped this damn thing, and on it, it says that you're the owner. It's like all these taxing districts all will agree that you're the owner of that property. Right now, you don't have that. Right? You have this thing they call a warranty deed, which wasn't done by a surveyor who's really the only one who's licensed to tell you, well, that's that property right there, and that person owns it. Because the survey isn't really going out and monumenting it so much. It's already been done. It's going and looking at all the records to see who owns what. This state officer is going to go look at the records. Yeah, that's what I want done. Right? So that was supposed to have been done for you, as we'll see, and you should have already gotten the title. And if you haven't, well, then that's a deceptive practice, and a deceptive practice is a crime. And because we're really talking about the small amount you put up as earnest money, taking the small claims court, because it's cheap to do, get the defendant properly served, get them to file their answer, and then request alternative dispute resolution and get the judge to order it. Sounds like a plan. It isn't quite how we did it, but now having done it, it's like, well, that would have been the easy thing to do from the beginning. But it comes down to, in this case, in Texas, there's this thing called, in the Texas Rules of Civil Procedure, Rule 503.5, Alternative Dispute Resolution. It says a state policy, the policy of the state is to encourage the peaceful resolution of disputes through alternative dispute resolution, including mediation and the early settlement of pending litigation through a voluntary settlement procedure. For that purpose, the judge may order any case to mediation or other appropriate and generally accepted alternative dispute resolution process. Now, in the contract that the homeowner has with the broker, it says in there, it says mediation. If there's any disagreement, both parties agree to mediate it. So it's already built into your contract. So you don't have to be in foreclosure to do this. As the homeowner today, if you think you own the house, the property, you don't own it. Somebody else got legal title. But you could have it if you went and made them give it to you. So is court-ordered mediation mandatory and binding? If a judge orders the parties to a lawsuit to attend mediation, they must obey and attempt the process in good faith. And again, the Supreme Court said courts have no jurisdiction over matters of faith. But a mediator does. As with any other judicial order, a party that fails to comply with the court order directing mediation can be held in contempt of court. Penalties for contempt can include fines and jail time. A mediator does not make a ruling or enter a judgment. Instead, they try to assist the parties in negotiating and memorializing an agreement among themselves. If this is successful, the parties can alert the court, have their case resolved. They can agree the parties proceed with litigation, asking the judge to schedule a hearing or trial to settle their disputes. Well, outstanding. So in our case, the judge had already sent it to trial, right? We're supposed to have a trial date on May 6th. So like 60 days from the date that the judge issued his order, it was an order for trial. And then after that, we ended up putting in this document, and the judge says, well, I consider that you moving the court, basically. And so he's ordered alternative dispute resolution. So let's look at it instead of me just talking about it. Hang on a second. Yeah, so let me just click through a few documents here, right? So this is the order. Case number 245100054 where it said that on 3/12/2024, the plaintiffs submitted their request for alternative dispute resolution. So let's just stop. What did the judge say we did, right? The judge said we put in a request for alternative dispute resolution. Now, whether you call that motion for this alternative dispute resolution or request for alternative dispute resolution, or in our case, we put in a notice about alternative dispute resolution that the judge accepted as being a request and granted the request. Put the seal of the court, and apparently that's his signature. Is that your signature, Judge? You know, if you pointed at that and said, is that your signature, Judge? And he shook his head yes, or said yes, then that scribbly line is his signature. And just a real quick review, right? This is the buyer representation agreement between the buyer and the broker, when it says in definitions that closing in a sale transaction means a date legal title to property is conveyed to the purchaser. Simple enough. What's property means interest in real estate. Okay? Broker's obligations, so forth. So, you know, our whole argument lies on this, right? Well, you've been paid, because down here it talks about him being paid, right? Where are you? Closing, close. Here's how he makes his money. This talks about his fee, right? Earned and payable, and there's a difference because client enters into contract. Right? Commission is payable either during the term of this agreement or after it ends upon earlier of the closing of the transaction to acquire the property, or the client's breach of contract to buy or lease the property. Well, they took our money, so, you know, that's the way she goes. There's mediation. The parties agreed to negotiate in good faith. Well, there you are. It's all laid out to be had. All you got to do is go get it. And you get to the bottom, and, well, there's the broker. They signed it, and there's the client. She signed it. I want to show some other thing too, though. Forgot to mention. Right, they did not use her full legal name. It should be Kimberly Renee Price, right? No full legal name, and they didn't put an address for her. And you know, they do this stuff intentionally. This is just some of the things that are wrong on the paperwork, right? But there's the agreement with them, and then here's the agreement with the homeowner, what you're buying, and this is what they say you're buying, the property. And you'll find out that in her case, that this information doesn't at all match up the information that's on the deed of trust. And I don't believe it's the, in fact, it wasn't the same on Bob's in Arizona, right? That what you're saying that you bought, the description, so this is what you're buying, this is the legal description or the description of the property, isn't the same description that they use for the legal description on the deed of trust or the warranty deed or the mortgage. Things to do with the money. They make up a different one. Okay, and this just shows it all happened and what was supposed to happen. And so I've already gone through all this in these other videos, right? But I just wanted to show that these are the two documents that have signatures on it by both parties. And so, you know, we have a contract. There was a broker information, so he was on this one also. There's the signature of the buyer and the seller. Right? And this is a big deal. See, this is supposed to be filled out by the broker. Broker, fill in, date, final acceptance. And it said to put the blank day of some month, 2000 something, right? Instead, he put month, day, years. They've even put it in the wrong order. They didn't follow procedures, and so this is, a deceptive practice. Got all sorts of things to point out if we could ever get it into court, or in this case, even better, get it to mediation. Okay, and so somewhere in this county, this map is, it has all these people, all these different offices that signed off and bam, 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 bam. You got this box and a red arrow pointing to the box, and then you got a circle around here. I didn't do this. This was all on here when it was given to the homeowner. How many times I have to do this? Get there. Yeah, right here. This is right. So by their seal or stamp or whatever, all these different taxing entities have all agreed that the owner is, and this is the thing, it's Quinco Investment, which is the people that the homeowner bought it from. So it's still in somebody else's name. It's not in her name. Now, Quinco probably doesn't even know this happened. I don't know if they know that this is going on. Possibly they do, and they're the reason for it. But that's up to the broker, because our deal is with the broker. All this other stuff that happened in the transaction was done for us, but you don't have a contract for it. The only people you have a contract with is from the very beginning with the broker. And then you sign the contract to buy the house, so where's the freaking legal title? Where's this map with my name on it? And then along with that, or from that, is generated some kind of tax certificate, I guess. It's issued to, because this is the owner. It says what the legal address is, the parcel address, the legal description, and that they're the certified owner. Right? If you don't have this stuff, then you're not the owner. Now, they're going to try to give you stuff that looks something like it, but it isn't the same thing. Right? And this is the big one, because this is the one that starts everything. This is the one, this is the legal title, this frickin' map, or the survey that produced the map. And then, in her case, that she got this commitment for title insurance sent to her, previous to the transaction happening, and had Schedule B, which was usually a Schedule A and a Schedule B, exceptions from coverage. And it's talking about here, any discrepancies, conflicts, blah, 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 boundary lines, encroachments, protrusions. Company has approved the current land title survey. And upon request and payment of any programated premium, this item will be amended in the policies to be issued to read shortage in area. But the thing is, the current land title survey, right? That's what you want is, this is Texas. Maybe they call it a land title survey. But in a lot of places, and this is out of the manual surveying instructions from the Bureau of Land Management. All right, that the land ordinance 1785 and several ordinances and instructions that followed require that as surveyors establish each line that they were to make it real, to actually carve a line into the landscape to blaze the trunks of those trees, those branches, brushed lines, to dig trenches, mound rocks, and otherwise chisel linearity into the very face of America. So they actually, surveyed the whole country. They did it by this thing called a... So just really quick, what can the book tell us? Well, prior to the Constitution's adoption in 1788, and while under the Articles of Confederation, our Confederation was still in effect, Congress passed a land ordinance of 1785 establishing a system of surveying and thereby demarcating the public lands. Since the land ordinance, it has been a continuous policy in the United States that the land shall not leave federal ownership until it has first been surveyed and approved, and an approved plat, a survey, has been filed. Reference the original patent into the statutory authority as well as relevant survey, including survey monuments. Okay, this is talking about what they're going to do to get it. Let's see. These titles, let's just start begin. 30 of the 50 current states, public domain states, were originally surveyed under this system. With very few exceptions, all claims of title to privately owned land in those 30 states trace back to a federal land patent or to other grant. These titles contain written land description and locatable on-the-ground monuments established according to the original cadastral survey, which created not only merely located, identifiable land boundaries. In litigation concerning land boundaries in these 30 states, often it's necessary to determine what specific land left federal ownership under a given federal land patent or other instrument of conveyance, and what land remained in federal ownership. Reference to the original patent and to the statutory authority, as well as relevant survey, including the surveyor monuments, survey notes, and plat and instructions, are often needed for proper adjudication of modern land disputes in these 30 states, regardless of whether any federal interests are directly involved in the dispute. Land ownership and boundaries in the other 20 states, i.e. 13 original, Hawaii, Kentucky, Maine, Tennessee, Texas, Vermont, West Virginia, were established by other means, surveyed according to different system of standards. Well then, use theirs. So in Texas, they don't have a cadastral survey, so we can't use that word, right? So apparently they call it land title survey, because that's what was used in the agreement. So be it. Where's the land title survey? Let's see if there's any other little bits here. In general plan, each cadastral official survey includes a request for survey. All right, so in general plan, each cadastral / official survey includes a request for survey, special instructions, assignment instructions, field note record of the observations, measurements, and monuments, description of the work performed, and a plat representing the official survey. All are subject to review, approval, and or acceptance by the Director, Bureau of Land Management. A cadastral survey is not complete until it's officially filed with the BLM. Wasn't that something? You're not done until you give a copy to the BLM. All right, so it's a whole process that has to happen. But that's what gives you legal title when that's happening. You didn't have to do it. That's what you paid to have done. All right, that's the great thing. This is what was agreed to in closing. In a sale transaction means the date legal title to a property is conveyed to a purchaser. You paid for their expertise to do it, and they didn't do it. Well, it's a deceptive practice, taking a small claims court for the earnest money and, plan on settling out of court. You're not after the $3,700. You're after the legal title. Now, this may be for those other 13 places. You have either land title surveys or you have ALTA, ALTA surveys. What's a land title survey? Real estate title surveys. Maybe that's the proper name. No, I say land title survey. That's the proper name. Are usually required by title companies and or lenders for property purchases. These documents will depict boundaries, improvements, and other special details on the property. It's a very technical document, and Geomatic Solutions will take care of it for you. Texas surveyors are governed by the rules and regulations of Texas Board of Professional Surveying. Well, there you are. All surveys must meet minimum requirements of the TBPLS. For the Texas Society of Professional Land Surveyors, a land title survey is a comprehensive investigation and evaluation of significant factors affecting and influencing boundary location, ownership lines, rights-of-way, easements within and immediate surrounding a certain lot, parcel, or quantity of real estate. The survey locates, determines, or re-establishes on the ground the perimeters, division lines, or boundaries, an area of the certain lot, parcel, or quantity of real estate. land title survey differs from a traditional or standard property survey, and that the land title survey is for title insuring purposes, and therefore must include greater detail not normally gathered in tradition of standard property survey. GSI provides this service with excellence, right? Because the true title insurance is having your name on the frickin' survey as the owner. That's your title insurance, not the shit you pay for. No, this document here, signed by a frickin' state officer. That's your title insurance. When he says that you're the owner, well, then you're the owner. Okay, so we'll just take a couple, because we can. This is a nice thing. Harris County, you can look at all the documents, or at least parts of all the documents in their system. And, well, if you want to look at this one, this is the case number. I won't read it to you. You can read it yourself. And then you put up here, this is JP Odyssey portal .Harris County tx.gov/Odyssey portal JP/home. You know, so maybe you can get there. I don't know. Right? But that's what it is. It's Harris County Justice of Peace Courts. You call them and say, I want to look at some court cases. Maybe they tell you how to do it. But in our case, right, then you go there and you hit the little box there and submit. And, well, now you found the case. Kimberly Renee Price versus Real Broker LLC. You can click on it, and, well, you got case information, got the parties, got the cause of action, got the events. All right, original petition filed on 2/14, and we're at 3/17, so it took a month to get here, and we could have had it sooner if we'd have just gone directly to motioning for alternative dispute resolution. And, yeah. Defendant's answer. All right, service return. Well, let's look at that. We'll go look at the... It's kind of hard to look at the petition out here because of the way they're putting in. Like this says it's pages 4. But you look here, there's only really 2 pages. And you go to download this, and it downloads in some format that I can't open. So maybe that's how you see the other 2 pages. But right, so we filed a petition with the court. And when we did, we used as the address of the defendant the address of their registered agent and did a care of. Right, so name of the defendant, Real Broker LLC, care of Corporate Creations Network, right? Which, you know, is a person, right? It's a business, so under these statutory laws, it's considered a person. So by taking it to them, it's personal service. And you could mail it to them, or you could maybe fax it to them, or take it down to their office, whatever you had to do. So that's what and in Texas, it's all done through the court. And when they went there, they got this piece of paper from that business. You know, it was like proof that it had happened. Where it says that Council Corporate Creations Network and United Agent Group do hereby authorize Regas and all of his staff, including not limited to these people here, to accept and mail all documents, including any and all court documents served or delivered by the court, private server, sheriff, court, or otherwise, of each business and each business entity represented by Corporate Creations Network Incorporated and United Agent Group Incorporated. This authorization includes signing on behalf of Corporate Creations to accept all mail and documents, including so forth and so on. So that's the thing. Now, I don't see where they signed anywhere, right? And that's what it says they could do. But apparently this was good enough. It's pushed the thing along. And, you know, based on this was proof that the petition had been filed. And then soon after that, we got the answer. Right, Real Broker LLC's original answer, subject to and without waiver of its right to stay this proceeding and compel arbitration. See, they even talked about it. Real Broker LLC files its original answer. Small claims petition in support whereof would specifically show the court as follows. Generally denies each and every allegation, both singular or plural. Right? Deny, deny, deny under some rule. Pursuant to, what did it say? And demand proof of each and every allegation by a preponderance of evidence pursuant to that. Now, we have the contracts, which you would think would be evidence, but there's a particular way that you have to enter evidence for it to be evidence into the court, which isn't necessarily the same as dealing in good faith with a mediator. Well, here's our contract, mediator, just show it to them without going through all the procedural things of court to get it to be evidence. Just bring in your, your agreement, say, well, this was our agreement. And then pursuant to these rules, defendant hereby notifies all parties of intent to use documents produced by any party or third party to this lawsuit at any pretrial proceeding or at any trial on this case. So that could be interesting. Defendant hereby notifies all parties of its intent to use documents produced by any party or third party to this lawsuit at any pretrial proceedings, which is what ADR would be, or at trial. So who knows? Maybe they'll come in with some paperwork we can look at, or implicate some other people and, throw them under the bus. As long as the person with the that has the survey with the homeowner's name on it shows up, well then, we're getting to the right people. Service by email, real hereby consents to receive these documents that way, and then they pray for relief. Defendant prays plaintiff's small claims petition, or any amendment or supplement thereto be dismissed with prejudice, and that relief requested by plaintiff be denied, and that all costs taxed against plaintiff additionally. All costs be taxed against plaintiffs. In other words, you pay their attorney fees. Additionally, defendant prays for such other and further relief in law or in equity, to which may have justly been entitled. And then this is the way it came, and it's like, well, they didn't. There's no signature of the defendant. It's only been signed by these attorneys, which then kind of find out this email address didn't work, and this email address didn't work. But out of these other four, because there was four of them up here, one of these worked, so they ended up getting served. They had their say, we had our say, and so now, as soon as this had gone in, the judge down here, he ordered a hearing for, these aren't all necessarily in order, for a judge trial. Right, I hereby notify a judge trial on the merits of the Justice Court is scheduled for May 6th. Okay, so a judge trial, not a jury trial, but a judge trial. Jury demand. You want to have one, so forth, so on. Right, so he immediately scheduled a trial. Well, soon after that, because he had done it immediately, we really hadn't even had a chance to do anything. We said, well, we don't like the answer. This is, the way I looked at it, the guy hadn't signed his complaint, so let's file it for a motion for a default judgment. Plaintiff moves for default judgment pursuant to 503.1. Plaintiff is entitled to default judgment based on the following facts. Defendant filed the answer in accordance with Rule 502.5. The answer small claims case form from the Texas Judicial Court Training Center requires defendant's signature. A paper filed in this cause, we just looked at, as the defendant's answer was not signed by the defendant and cannot therefore be the defendant's answer. Well, they didn't buy that, right? That didn't seem to make any difference. In fact, they put down here that it was moot. Right? So you can go, well, let's go look up the definition of moot. Moot, English law. Ain't that something, right? They use the word moot, which is tied to English law, like we're not under the laws of the United States, we're under the laws of England. A term used in the Inns of Court signifying the exercise of arguing imaginary cases. Right? So a term used in the Inns of Court signifying the exercise of arguing imaginary cases. They say this is an imaginary case, which young barristers and students used to perform at certain times, the better to be enabled by this practice to defend their clients' cases. A moot question is one in which has not been decided. So which one was it? Something that hadn't been decided, or is it an imaginary case? It's amazing how they tie these completely different styles of, a definition of a word to the same word. Yeah, okay, and then we got certified copy and a set of additional documents, because when we put in this for default judgment, that's when we put our evidence in. Didn't put the evidence in with the petition, it was just a petition, because they had said when Kimberly went there that she could put it in then or put it in with the, at a later time. So, okay, well, we'll decide what it is we need later and put it in at a later time. And that's what we put in to show that here's what our agreement is. And, they didn't agree with it. Well, then they only put like 2 pages as being the motion for default judgment, and then they put the rest of them as additional documents. It's like, well, no, it was all supposed to be the one thing, the motion for default judgment, not 2 different filings. So it's like they took all our evidence and took it out of our filing. I don't think that matters anymore. Just I'm telling you the things that happened as we're going through this. So I try to figure out, why did they split our motion into 2 pieces? What would that have been for? Anyways, and then Kimberly got some return mail for, well, they actually have it in here, I think. Right, was from the judge, where they're saying they were trying to send this notice, because it's supposed to be mailed to her address of record. And then it went someplace that had nothing to do with that address. It got returned to sender. And we've taken this now down to the post office to find out what's going on, and they're kind of wondering themselves what's going on. I don't know if they're going to do anything about it, except, well, you can go file a complaint with the postal inspector. Yeah, well, I guess we could, but you would think you told the postmaster that they would care. Didn't seem to be the case. Nevertheless. Okay, and then, we filed what, again, was termed a notice, but ended up being decided to be a motion, right? Notice of Rule 503.5, Alternative Dispute Resolution Requirements. So, in accordance with Texas Rules of Civil Procedure, 503.5, which is just down from 503.1, which is the one we did for the reason before, just, kind of going through the rules and seeing what we could do. Right? State policy. The policy of this state is to encourage peaceable resolution. All disputes through alternative dispute resolution, including mediation, early settlement of pending litigation through voluntary settlement procedures. For that purpose, the judge may order any case to mediation or other appropriate and generally accepted alternative dispute resolution processes. Which again, this is why if you're in any kind of case now, especially if you're in there as a defendant in any kind of court case, you should file a motion and ask for alternative dispute resolution. Request alternative dispute resolution. You don't have to say anymore. And just see what the judge does. Plaintiff noticed defendant in court of plaintiff's willingness, or plaintiff notices defendant in court of plaintiff's willingness to utilize alternative dispute resolution, mediation, and the early settlement of pending litigation through voluntary settlement procedures to peaceably resolve the ongoing dispute regarding contractual obligations. Section 12 of the residential buyer tenant representation agreement signed by the defendant and plaintiff requires attempting to resolve disputes by mediation, something plaintiff endorses as being in the best interest of the defendant, as deceptive acts and practices are crimes in Texas. These people can't go to court. Man, if they lose, they're going to jail. It's a freaking crime. A deceptive practice is a crime. It's fraud. It's just that the law calls it a deceptive practice or act or practice, so call it that. Okay, and then order granting. Yes, order granting. Plaintiff submitted on 3/12. They signed on 3/12. It says 3/12, but it wasn't really 3/12 happening. Now, this is interesting, right? Now it says here, motion for mediation. But when we click on it, right, this is one we can't see. Online preview is not available in this document type. Click the purchase document or download document to obtain a complete digital copy of the document. I haven't tried that. Let's just do that and see what comes up. Yeah, no, it comes up with some kind of thing I can't open up. Motion for something, open file. I did it, didn't open up. Anyways, we'll have to find out what that's about, right? Because we didn't put that in. Somebody else put in whatever this document is here. Somebody else put in motion for mediation. All I know is that on the order, right, the plaintiff. Now it says plaintiffs with the S. Because there's only one plaintiff. I was wondering about this. It says plaintiffs with an S, with a there. No, it was us. But now somebody's like acting like they're on our side because, somebody filed a motion for mediation the day after the order was signed. Look at the dates, 3/13. Well, who did that? Notice, email file by plaintiff with attachment, corporate creator. What was this? Oh, I think this one went down, and yes, and besides trying to serve just using the email addresses, because this office wasn't too far from the homeowner, she just took him down a copy and, got the same thing from them that the sheriff's department got, and then we filed it in a court case. And that was for the the notice, which has now become a motion. And maybe that's what made it a motion. Maybe that's what this is. This is very interesting. I didn't know I was going to see this today, so we have to find out why there's a motion entered and why we can't look at it. And they're going to have to send the homeowner a copy of it and see what that has, see what it looks like. Right, so we got there by bumping into all the sides going down the chute. There was nothing clean about doing this. But what I can tell you after having done it is, well, really all you had to do was you had to file your petition and then get the defendant to answer. So now they're, tied into the court. They've appeared. Now the court has jurisdiction. And then file a request for alternative dispute resolution. And just call it that. And, be done with it. Let the court order alternative dispute resolution. And now go to mediation, just like the agreement said that you have you already had with the defendant. But the difference is because the court has ordered it, now they have to mediate in good faith, which apparently they didn't have to unless you could get the court to order it, or they wouldn't have said such a thing, right? But court-ordered mediation means you have to mediate in good faith. And we're going to find out if good faith means anything to these people in a very short period of time. Alrighty, and I just was realizing I've never really gone through what the petition was that we filed for this, so just real quick, I will. In Texas, they give you, you can find a small claims petition form you're supposed to fill out, and you can either get it from the court or find it online. But you put in, who you are, and see, this is the state of Texas and county of Harris, which that's the de jure, not the de facto. If it said state of Texas, Harris County, we'd say, well, that's de facto, or it's administrative state, or it's something other than the de facto state, like two different jurisdictions, parallel jurisdictions, and but in this case, we're going to the real one, the state of Texas, County of Harris. And defendant address. So when it came to what's the defendant's address, well, that's when you go online to the Texas Secretary of State and look it up and find out, right, Real Broker, LLC, that was their name, that was their address, and here's their registered agent. And so this is who you actually serve, right? This is the care of. We're going to send a Real Broker, LLC, care of Corporate Creations Network Incorporated at that address. And, you know, if you mail it, they should be the ones that return you the green card if you did it certified mail to show it's been done, or you could take it down there, or you could tell the service company you're using to take it to them, whatever it is, because that's the proper people to contact if it's a legal matter having to do with the with their client. Right, and so for $3,800, and then what was it going to be for? Well, we'll put that on, you know, use additional pages, which we did, and basically said something like this. Right, and this was all just referring back to the two documents that have signatures on between you and another party, which is the broker's agreement with the broker, and then the buyer's agreement with the seller, buyer-seller agreement. Okay, so by the name Kimberly Price, that was the name they used. Petitioner is named client party, and defendant is broker party on Texas Realtors Residential Buyer Tenant Representation Agreement. Yeah, just put it in there. You got the information, write it down. Form number, whatever it is, bilateral business contract executed by petitioner on that date, which upon which defendant contracted with petitioner to be appointed as petitioner's real estate agent and intermediary for purposes of petitioner acquiring property in exchange for commissions payable the date legal title was conveyed, closing to purchase under the contract. What's going on there? Well, that's all has to do with this thing. All right, when legal title, that's when we're done. Whatever date you get legal title is the day that you're done. Right, which is payable, so this broker's fees are payable on the date legal title was conveyed, which is the closing date. And that came from when it was payable. Let's look at that again real quick. Right, you go down here and read through your contract, and you're going to find out what their fees are and when it's earned and payable. And when we say payable is either during the term of the agreement or after its end, upon earlier of the closing of the transaction to acquire the property. And to close the transaction to acquire the property, they had to give you legal title. It's a wonderful concept. Okay, with defendant as petitioner's intermediary, petitioner by the name Kimberly Price became the buyer party on Texas Real Estate Commission, TREC, new home contract executed on some day between buyer and some seller, upon which the defendant is identified as the broker, representing the buyer only as buyer's agent for the purchase of property known as, and I gave an address, property more specifically identified as something in the city of Houston. Take notice that no other property description is attached as an exhibit to this contract, because it said there could be attached. As the petitioner's real estate agent, the defendant induced petitioner to wire transfer $140 option fee and earnest money in the amount of $3,700 to Universal Title Company, acting as escrow agent to initiate this transaction. Although defendant's employees telephonically confirmed to petitioner the defendant's being paid the contractually agreed broker's fees, the legal title certifying petitioner as owner of this right here, which what she said she was buying, right? That's that property description has not been conveyed to the petitioner or buyer. No plat, map, tax certificate naming petitioner as owner of legal title has been provided by defendant as proof of conveyance of the property to petitioner. Instead, the defendant insists that a document filed as general property record with the Harris County clerk, the general warranty deed, naming a fictitious Jane Doe. Right now they got Kimberly R. Price, an unmarried woman. That's the name of the grantee, this whole thing right here. Which, first of all, the buyer didn't use a middle initial in her name. But this is that's the grantee. Well, that isn't the same name as a buyer, so this agreement has nothing to do with the agreement for the legal title. But they're trying to make it sound like it does. With a fictitious property address, and then they use a completely different address than the one that is on the description, right? This one talks about it being in a subdivision of Harris County, Texas, according to map of plat thereof, recorded somewhere by Harris County, Texas. But on the thing that, on the agreement, it says Birtwood Estates Addition, City of Houston, County of Harris, Texas. So this is a completely different legal description. This isn't what she bought. So don't let them bullshit you. Petitioner rebukes defendant's assertion and seeks economic damages, exemplary damages, and other relief this court deems equitable for defendant's malice, gross negligence, unconscionable actions, false, misleading, deceptive business practices. Just throw it on there. Cover it up. Right? And then we did it authenticating, because it has to have your signature on it, right? So you need to authenticate your signature somehow. Now, I guess if you did it in front of the court, that could be fine, because they're going to use the court seal. But if you're doing this outside of court and bringing it to them, the one way to do it would be to do a declaration that I declare to the attesting witnesses that this document is my free will act and I sign it willingly, that by my signature I execute it, and I'm 18 years of age older, under no constraint or undue influence, and I have sufficient mental capacity to make this verified statement to incorporate into a small claims petition. All right, what are you doing it for? And fill it in, and then you get your attestation clause that we, the undersigned witnesses, 2 of them, respectively, hereby certify and attest we believe the claimant to be 18 years or older and a sufficient mental capacity when she signed the foregoing document in presence of both of us, being present at the same time, and we attested her signature in the presence of her and each other. So in other words, you get you and 2 witnesses in a room and you all sign the papers at the same time, and that then verifies that that's your signature. So now you can send it to somebody and they have to accept it, unless it had to be done before somebody who can administer oaths, which in this case it didn't have to be. But there are times that that you do, and that would be like for the petition itself, where I think it said on the bottom of the petition. Wait a second. Right at the petition itself says that you have to do the petition for them. But, technically this other document was an addition to, so, I guess you could have. Either way, it was done because you went before the clerk of the court to do it. My point is, if you're verifying your signature, that this is I pointed this out in a previous video, that this is how they do it on with an attestation clause. Right, just to verify, because when they ask for your signature on something, you have to be able to say that's your signature. And this is how they do that, with an attestation clause. Well, very good. Hey, that's where we're at today, right? It's in. ADR has been ordered, adjudged and decreed by a small claims court. Right? And they agreed that alternative dispute resolution was the right answer. And so now the deal is to settle. And what are we settling for? Well, the only thing that you have a contract for with the broker is the legal title. It has nothing to do with the money, right? Forget the fucking money, forget the loan, but this is just about getting the title. One thing at a time, right? Let's get the title. And now we'll go after the people for the money. Sounds like a plan. One thing at a time, though, right? But that's the answer. You need to ask for alternative dispute resolution. So if you're in a foreclosure case right now, you should ask for alternative dispute resolution. And then make them bring in their proof to the mediator. Because there isn't any proof being put in these court cases. Not any, it's all hearsay. And then the problem is that the attorney is an attorney, he's in the club, so he gets a higher, the board is inclined in his direction. All right, things are working out for him. The scales. Okay, very good. I hope you found it informative, and I wanted to at least get this out so I could say that I had, and we're all caught up. We'll let you know what happens next. See you now.